Good morning, everyone. That was kind of half-hearted. Good morning, everyone. Yeah, there you go. It's supposed to be 40 degrees in Detroit today. We should all be excited. This is fabulous. It's not that warm in Grand Rapids, that's for sure. So on behalf of myself, Judge Garrett and Judge Bozzi, welcome to the first day of our Detroit case call for panel number 3. We appreciate your presence here today, both in person and via Zoom, and we understand these cases are very important to you and the litigants. I want to assure you that we have been diligently working on these matters. We have had the benefit of your briefing as well as the work of our research division and our law clerks. We're familiar with the relevant facts and pertinent law, and we ask that you focus on your salient points, keeping in mind our role as an error correcting court. Please also know that as 3 former trial judges, we like to ask questions, and we'll be doing so if you believe it's necessary to rehash all the details in your brief. Please also let me know if you wish to reserve any time for rebuttal. I'll do my best to accurately keep time while also taking notes. Additionally, we have individuals participating via Zoom. If you could stay close to the podium when you're speaking and don't go very far from the microphone so they'll be able to hear you. Also, please make sure you clearly state your name for the record when you approach the podium. And finally, we are hearing several matters involving sexual assault victims, personal protection orders. I think not this time though. And children, because these proceedings are recorded and live streamed, we ask that you substitute initials in lieu of the victims, petitioners, respondents, or minors' full names in these cases. With that, we look forward to hearing your arguments, and we're going to begin by calling docket number 1. This is docket number 347854, People versus Roy Deshawn Abrams. Counsel?
May it please the court, Ali Wright from the State Appellate Defender Office on behalf of Mr. Abrams. I'd like to reserve about 3 minutes for rebuttal. I'm not sure if we'll need the full time though.
Very good. Go right ahead.
Mr. Abrams' case presents this court with what I see to be a fairly simple question. Does a defense attorney provide constitutionally effective assistance when he fails to read every page of discovery produced by the prosecution? Pages specifically that are introduced into evidence by stipulation against his client to secure his client's conviction. And I really hope the answer to that question is no. I do think an example, for example, if a doctor did not read every page of their patient's medical history, and because he was ignorant of what was in those pages or in that history, he failed to consider or employ certain treatments or measures, treatments that he later admits that once he was made aware of what was in those pages, he would want to employ, there would be serious concerns about whether that patient got the care or received the care they deserved. And similarly here in preparing for trial counsel did not do what is required of every attorney. He did not review every page of discovery in this matter, specifically every page of the complainant's medical records, whose admission into evidence he stipulated to. And I'm well aware that reviewing 1,700 pages of medical records is not an enjoyable task. It's not fun, but unfortunately, it is something that is part of the job. It's something you have to do as an attorney to effectively represent your clients, your responsibility to do so.
Counsel, were the records like electronic, so you could do like a control F and look for terms or things, or are they just pieces of paper?
I'm not sure how trial counsel had them. I'm not sure if it was for him. I know I had them electronic, but for example, one thing you'd have to do potentially is you'd have to, I'm blanking on like the technical terms, but make it searchable. And again, I'm not sure if trial counsel A had them in that form, let alone B knew to make them searchable like that. But regardless, I think the point is, and this is, I really do think this is borne out from his testimony. It became very clear at the beginning there that one, he said he hadn't reviewed every page. 2, he just said, well, the ones I did look at, I looked carefully, but that can be problematic because if there's something important on a page you did not look at, then you've missed it. And three, I think also we can kind of see that he missed some of this important stuff because, for example, the cocaine, the abdominal or intestinal complications that the doctors felt were induced owing to the complainant's long-term history of cocaine abuse. That's mentioned throughout those medical records all the way over the course in different spots numerous times, and trial counsel wasn't even aware of that. So I think his spot treatment, like even if he did a proper spot treatment, surely he would have at least been aware of that, given that it comes up a bunch of times over the course of on page 1700 as opposed to 10, as opposed to 50, as opposed to 750. It comes up numerous times and he was unaware of many of these things that were in there. And so I really do think that shows a concerning. We all want to be effective. We all want to think or consider that we looked at something carefully, but that's always conclusory. And so when that conclusion of did I do so carefully, I think when you really dig into that, the fact that this stuff was missed kind of shows that maybe it wasn't as carefully as trial counsel actually thought. Because trial counsel did not review every page, he failed to learn the true impeachment value of the medical records in this case. And he testified that had he known what was in those portions of the medical records, he would have wanted to direct the jury to that information. And specifically, we're talking about that there's nothing in there that the doctors were considering anything about a leg amputation. There's nothing in there about the complainant's receipt of this intestinal discectomy, which I would posit is a fictitious procedure. There's nothing that, in fact, the records actively refute a leg break. They say no leg break over and over and over again. And the doctors felt that the complainant's, as I said before, abdominal intestinal complications were owing to his long-term cocaine abuse. So we know that trial counsel was unaware of this information, testified at the Ginther that he had read every page, that he had missed some of these portions in the medical records. That was his testimony. And I do want to be very clear about Mr. Abrams' position here. Mr. Abrams does not argue that trial counsel should have adopted or employed a different trial strategy, as the prosecution suggests in its brief. That's not our argument. His position is that trial counsel did not properly execute his own chosen strategy. And so my dad always kind of told me this growing up. I think it's a common saying, if you're going to do something, do it right. And I think that kind of rings true here. Trial counsel chose the strategy of challenging the complainant's credibility and portraying him as a lying, and this was his words, a lying crackhead. And that's fine. We don't dispute that. His strategy, that's fine. And to employ that strategy, trial counsel chose to direct the jury to the complainant's medical records. That's what he chose to do for impeachment purposes. Great, fair enough. But because trial counsel had not read every page of those records, he only directed the jury to 2 or 3 trivial inconsistencies, something about a discrepancy with respect to the complainant's cigarette smoking habits, and another discrepancy about him being essentially a stubborn patient. And then worse yet, and almost more importantly, trial counsel actively directed the jury away from the stronger impeachment that we've put forth in the brief. And he did that inadvertently because he didn't know it was in there. But by telling the jury, hey, only focus on these 2 or 3 pages, when he didn't even know it was in the rest, he directed them away from stuff that he later admits or that it posits is significantly more powerful or impactful in terms of assessing the complainant's credibility in this matter. That's not strategic. He did not know what was in the records or what they contained, and that, as a result, is not objectively reasonable conduct. I've talked a fair amount about deficient performance, just briefly on prejudice. There's a reasonable probability of a different outcome in this case had trial counsel directed the jury to the information that he missed in the medical records. This was a strict credibility contests, and the jury was really left with determining there's only two men who can really speak to what happened that day, Mr. Abrams and the complainant, and the jury had to decide who they believed, whether it was the complainant's story that Mr. Abrams assaulted him over some missing money, or Mr. Abrams' version of events that he acted in self-defense after the complainant got high on crack and attacked him over failing to pay him for some electrical work. And I really think the important thing to note here is the complainant's credibility was already pretty shot. There's a jury acquitted on the torture, unlawful imprisonment, and assault with intent to murder claims or charges, which are all very serious charges. And I think this is a bit where the trial court gets things wrong. Had trial counsel directed the jury to all the things we've been talking about, no leg break, amputation, et cetera, the cocaine abuse, it's not that this information would have been cumulative and therefore of little value, as the trial court found. I really think it's the opposite. Rather, there's a reasonable probability that such information would have destroyed what little credibility the complainant had left. And I think their acquittals on those charges really supports that. But and I think the other thing that the trial court errs in here is, but again, it's de novo review, is that there's this false premise that I think the trial court operates under, because that just because Mr. Abrams was acquitted of some charges that he necessarily must have received effective assistance. But just because someone is acquitted of some charges does not mean that he necessarily received effective assistance with respect to the charges that he was, in fact, convicted of. And Mr. Abrams was convicted of great bodily assault with intent to do great bodily harm here. He's serving a very long prison sentence. And so there were very real consequences, a 20 plus year prison sentence, I believe. And so there's very real consequences here from his conviction. So to bring us full circle, at the end of the day, this court has to decide whether indigent people living in Michigan get the quality of representation afforded to them by the Constitution when their attorney does not read every page of the evidence that is being used against them and in ignorance directs the jury away from stronger impeachment that he admits he would have wanted to highlight for them had he known about it. And again, I hope the answer to that question is no. Our courts have held that strategic decisions cannot be made from a position of ignorance. But that's exactly what happened in Mr. Abrams' case. So Mr. Abrams asks that this court uphold that principle and grant him a new trial.
Questions?
I have a question. What about the statement that he makes during the Gifford hearing? He felt the jury would have understood that the complainant was a liar and would have stepped up. And I think he did testify that he could not recall all of the records. I think he accepted the fact that there were certain particular would have wanted to cross-examine on it. But we also had these hearings. And so what about his statement that at a certain point he would have, I understood it, he would have stopped pointing some of that out because he would have felt that the jury understood it. And so isn't that trial strategy? He doesn't want to maybe turn the jury off, something that nature.
Thank you, Your Honor. I would agree with that position if he said, yes, I read every page. I remember that all the stuff you're bringing out, the cocaine, the leg break. Yes, that was in there. And I chose, because I only have X amount of time to do my closing, I chose to focus on the things I wanted to, specifically, the cigarette discrepancy or him being a combative patient. I chose to focus on that. And I chose not to focus on those other items in there that you're raising with me now, counselor. But that's not what trial counsel said. That's not his testimony. And so to answer your question, how is this not strategic? It's because he doesn't know about it. You can't make a strategic decision from a position of ignorance. If he knew about it and read it and then said, you know what, I'm going to choose, I know options A and B, I'm going to choose option A. And it doesn't work out. Yeah, I agree. I would agree that that's that's hindsight being 2020. I lose. I agree. But he was unaware of these things being in the record, and as a result, he cannot make a strategic decision. So regardless of how he would have maybe wanted his argument to be more tight or focus on one thing over another, he can't decide to focus on one thing over another because he doesn't know what the other says, and specifically the leg break, the cocaine induced. I've listed those things. I hope that answers the court's question.
Did an opening argument, can you refresh my recollection, did the prosecutor mention about the fact that there was the leg break, there was the dissection, the intestinal dissection, which again, we don't know if that really exists.
Sure.
I know those were in closing and he really pushed those, which then had defense counsel knowing about it, he could have said, look, on page 27, there's this, on page 365, there's this. He didn't have a broken leg. He didn't have anything with his intestines. So do you recall whether or not the prosecutor mentioned those issues, those three that you're talking about in opening?
I don't recall whether the prosecutor mentioned them in opening, but I think your Honor's questions also go to how much notice trial counsel had in terms of whether these things would be litigated or put on. And he did with respect to the prelim. These were brought up at the prelim for sure, in terms of the leg break, this intestinal discectomy, and I guess we can decide whether that exists or not. The amputate, these things were brought up in the complainant's testimony at the prelim. Trial counsel was on notice that these were the injuries that he was alleging that Mr. Abrams had inflicted on him, and more importantly, that he alleged that Mr. Abrams had inflicted upon him illegally. So he was on notice of this. And I'd also posit that he was particularly on notice of this because there was an agreement to stipulate to the medical record. So there would have been at least a conversation about that well before closing argument.
Yes. No question. Thank you so much. You have plenty of time for rebuttal.
Good morning to the court. Amanda Smith, Wayne County Prosecutor's Office, on behalf of the people of the state of Michigan, the plaintiff appellee in this matter. There's a long road to get this case back to this court after the parties agreed to a remand for an evidentiary hearing. I think it was right before the pandemic. Spent 5 years at the trial court level arguing about a Stanaway issue and then having the Ginther hearing. I believe it was July 1 of 2024. And as Your Honor noted, Mr. Jordan, when he testified at the Ginther hearing, was, very frank and candid with the court in that, in his preparation for that testimony, he had only reviewed, I believe, his closing argument from the trial. He had not reviewed any of the discovery or the remainder of that trial testimony, the transcripts. So he was doing his best to recall, his strategy, what he had reviewed, and his preparation heading into the trial in 2018. Fundamentally, the issue that I hear brother counsel arguing this morning and the, issue that he raised in his brief on appeal, criticizing Mr. Jordan's failure to completely review the 1,700 pages of medical records that were admitted on a disc into evidence at this trial. I just fundamentally disagree with Mr. Jordan's testimony on that point. I read it differently than brother counsel. Mr. Jordan, as I said, testified at the Ginther hearing that he had only reviewed his closing argument prior to his testimony at the Ginther hearing. He had not re-reviewed those medical records. He testified under oath that he did carefully review the entirety of the discovery, including those records, before he stipulated to their admission into evidence at the trial, that it was his practice to carefully review the discovery in every case.
Excuse me, counsel. I don't know that he actually testified that he did review all of the 1,700 records. If I recall correctly, he said, that's typically my practice, but I can't say that I did. And then he also testified and said, the bottom line is, I would love for those jurors to have known everything and anything that would have acquitted my client. That's the best answer I can give, which also, to me, kind of signifies that if there were information, and it appears that there may be information that would have acquitted his client, that he wasn't aware of it. And because he didn't. He thinks he did, but he didn't say that he actually read all 1,700 pages. And so I just want to clarify that.
Right. And
Okay.
I believe, I guess I can't recall what I said 2 minutes ago, but thought I was saying what Your Honor has said. That Mr. Jordan testified at the Ginther hearing that he couldn't say under oath 6 years after the trial in this case, without having re-reviewed any of the material other than his closing argument, he could not say under oath that he had reviewed every single page of the 1,700 documents comprising the people's exhibit for the medical records. He did say that at the Ginther hearing.
But Mr. Wright brought up the fact that the testimony by the complainant regarding the broken leg, regarding the discectomy, and those points have been brought up at the prelim. So as defense counsel going through these, and you said they were on disc, you can do a search for discectomy, you can do a search for amputation, you can do a search for broken leg. And it doesn't sound like he did any of that.
I don't know that he was specifically asked the question at the Ginther hearing. Did you have those medical records on a disc as opposed to printed out, as Your Honor indicated? Could be a possibility. And did you run a word search? Did you make that document searchable? And did you run a word search? I don't recall if he was specifically asked that question at the Ginther hearing. However, Mr. Jordan did make use of the medical records at that jury trial. He did use them in his closing argument. I know that brother counsel criticizes the portions of the medical records that Mr. Jordan utilized in his closing argument to direct the jury to review the cigarette smoking, the use of cocaine, and Mr. Kendra being combative with hospital staff when he was at the hospital. He did direct the jury to those pages of the medical records, which at a minimum signifies that Mr. Jordan did, as he testified at the Ginther hearing, review them. As I said, he was very candid that he could not say comfortably under oath 60 years after the jury trial, did I review every single page? He testified, no, I cannot say that comfortably under oath 6 years after the fact. However, it would have been my practice to review the entirety of the discovery, and I did carefully review the medical records before I stipulated to their admission at the trial.
Then again, he pointed them out to 3 relatively innocuous things about the cigarette smoking, combative with the people. And, you know, he testifies that I wasn't combative, and the records might say that he was, but they're major things. I mean, the prosecutor brought to bear the fact that he, you know, practically amputated his leg. He had this, he lost, was it 2 feet? He kept saying, I lost 2 feet of intestine or 20. He gave some very large amount of space and length of intestine that he lost because of this. And the record shows none of that. So, I mean, it's choosing to like parse words with these little things as opposed to these very large things that go with the assault with intent, right? And so that's what's kind of mind-boggling to me.
So Mr. Jordan, to take the first point, Mr. Jordan, I believe, pardon me, did indicate to the jury when he talked about things like the cigarette smoking, if Mr. Kendra is going to lie about something small, and this is what I'm using the medical records to show the discrepancy of what he said under oath at this trial and what he said in the medical records, if he lied by something small, then it supports me, you know, defense counsel arguing that Mr. Jordan, or pardon me, Mr. Kendra is going to lie about something big. He made that point to the jury using the medical records in order to do so. I believe we covered this ground at the Ginther hearing as well, the idea about like, what are we going to call that intestinal surgery that Mr. Kendra testified to? The intestinal, I'm not sure how to say that word, but your honors all understand the discectomy, I believe. Mr. Jordan, I believe we covered that ground at the Ginther hearing. Maybe Mr. Kendra misdescribed the label that was put on the medical procedure that he had, but there was no dispute in that 1,700 pages of medical records that he had a major intestinal surgery, and he was in the hospital for nearly 3 weeks, went to rehab, and then went back to the hospital. At bottom, there was no dispute that Mr. Kendra had a major intestinal surgery as a result of the assault perpetrated upon him by the defendant.
Weren't those the May 2018 records that were not introduced at trial?
The 1,700 pages of records included the intestinal surgery. There were separate records about the leg break, which I'm certainly happy to talk about because I know that that particular material was not admitted as an evidence at the jury trial.
I thought the May 2018 records that were not introduced at trial were the ones that the complainant showed that the complainant had this.
If that's what the record shows, I don't want to I can't dispute with the record that you may be referring to shows, but from my recollection in that 1,700 pages, represents the bulk of that initial hospitalization that Mr. Kendra underwent in this case. And that included the intestinal surgery that he had initially.
So you're not sure, because it's my understanding there were 3 sets of medical records and only one of them was introduced at trial.
Yes.
And yet at the Ginther hearing, all 3 are introduced at trial. However, the information that was introduced at trial in those medical records don't fully support all the testimony, but there might have been medical records later on that weren't introduced that might have supported some of the testimony. Am I understanding this wrong?
And no, I agree with you. And I'm specifically thinking about the leg break issue because I believe this came out at the Ginther hearing. So in my recollection, the medical record disc that was admitted in evidence in this case, the 1,700 pages of records, there was an indication that they had done like a CT scan, an MRI, or an X-ray of some sort, and they found no leg break on Mr. Kendra. And that is true. That is what the records say. However, in the material that was turned over in discovery, and I believe, again, this ground was covered at the Ginther hearing, within 2 months, I think, of Mr. Kendra's initial treatment in the subsequent set of medical records, a leg break was found, and the medical records indicated that the leg break that Mr. Kendra suffered was initially missed by the treating staff, and he was treated for that separately.
And I guess I understand that, but wouldn't it have been trial counsel's responsibility to make sure that the records that were introduced at trial were actually supporting the testimony of the testimony that was being provided by the people? I mean, we have 3 different sets of medical record. He stipulates to only 1 set of medical records. And couldn't he have pointed out all even if we learn later there's other medical records that support it, shouldn't he have been pointing out the fact that these medical records that were introduced simply don't support any of the testimony?
I mean, given the wide range of options the council has available to him, he certainly could have done that. He could have, and I believe in a brief filed by brother counsel, it may not have been, it may have been in the pre or post trial Ginther hearing briefing that we did in this case. I believe that brother counsel made that exact point that Mr. Jordan could have argued to the jury, stood up and told them in his closing argument, Mr. Kendra testified to you that his leg was broken in this result, but look at the 1,700 pages when you go back into the jury room, look at these records. It does not say he suffered a broken leg. I believe brother counsel made that argument previously, and I agree that is something that Mr. Jordan could have done. These are all things that Mr. Jordan could have done. There's no dispute about that. We can imagine a lot of things that Mr. Jordan could have done at trial. The question under Strickland is just, did Mr. Jordan perform reasonably when he crafted a trial strategy in this case, and did he execute it reasonably at trial? If we're just going to focus on prong 1, whether or not he made an error, and then secondly, we talk about prejudice. Yes, he could have done all these things. And I spent a lot of time in my brief file with this court candidly agreeing with that and really trying to drill down on what Mr. Jordan chose to do in this case. He chose not to focus a lot on the physical injury suffered by Mr. Kendra because his client testified that everything that happened to Mr. Kendra physically in this case, Mr. Abrams perpetrated against him, meaning that these 2 men did engage in a physical altercation, and Mr. Abrams testified it was in self-defense.
But again, that's the point. So if he's talking about the being conflicting with the people at the hospital, the cigarette smoking, the little things, then you follow up with the big things. He says he broke his leg. There's nothing in the report that says he broke his leg. He said he lost, 2 feet of intestines. There's nothing in the report that says he lost anything. Do you know what I'm saying? It's like you set the stage, right? And then you finish it off. And he had nothing, even though he knew that that was a point that was brought up in the prelim.
So again, I hear your honor indicating, as I, hear echoed in brother's counsel brief, that Mr. Jordan could have referred the jury to different parts in the medical records that either did or did not support Mr. Kendra's description of what he physically suffered in this case.
But he said, all you have to do is look at these 3 pages, which are the itty bitty things, not the no leg break, no loss of 2 feet of intestine. I'm just kind of astonished.
Okay, again, fundamentally, looking at how Mr. Jordan decided to approach this case, and I believe he spent a lot of time at the Ginther hearing describing his strategy in this case. He did not want to spend a lot of time on the physical injuries that Mr. Kendra suffered because he understood that his client admitted to perpetrating them, under oath when he testified in front of the jury. And again, coming back to, I believe Mr. Jordan testified to this at the Ginther hearing, that the medical records admitted and evidence showed that Mr. Kendra had a major intestinal surgery as a result of being stabbed by Mr. Abrams in this case. Whether or not Mr. Kendra used the correct descriptive term to describe that surgery, I don't know that that's really been established, but fundamentally those records established that he did undergo that surgery. And again, the medical records that were not admitted into evidence, however, are part of the discovery that Mr. Jordan did say that he carefully reviewed, do show that Mr. Kendra suffered a leg break. I also take issue with the idea that this was a pure credibility contest between two men, and that's all the jury had to go off of. As I indicated at the closing end of the error prong under Strickland of my brief, the 911 call was critically important as well because it corroborated Mr. Kendra's description of what happened after being assaulted by Mr. Abrams in this case. He was basically rolling around outside of a Coney Island covered in blood, eyes rolling back to the back of his head, going in and out of consciousness when he was found by a passerby who called 911. That is categorically different from what Mr. Abrams testified as to how he left Mr. Kendra at the end of this assault. According to Mr. Abrams, as he testified to the jury, Mr. Kendra and he got into an argument in Mr. Abrams' car, and he let Mr. Kendra out at the side of the road, and Mr. Kendra walks away talking on a cell phone. Critically different from Mr. Kendra saying, I was dumped by Coney Island covered in blood, and I'm basically going in and out of consciousness. The 911 corroborates that testimony that Mr. Kendra gave to the jury. So, again, it was not a pure credibility contest.
But it was. You just set up the credibility contest, what Mr. Abrams said, what Mr. Kendra said.
Right, and corroborated by the 911 call.
But that's only one piece. That's only one piece. Credibility is a taking out the bricks out of the wall, right?
Mhm.
Who's going to take out more bricks and the wall's going to fall down? And who's going to be able to put up bricks that is going to stay there? So you just described one piece of that credibility contest, but this came down to who do you believe?
Yes, I hear you.
And I think that counsel did not provide critical information that was in the medical records to support Mr. Abrams' version of what happened.
Okay. I mean, again, giving the deference that's owed to trial counsel in his strategy, as he described it at the Ginther hearing, the people submit that under Strickland, there is grounds to affirm the trial court's opinion in this case. But unless there are other questions.
Okay, thank you so much.
Thank you.
Counsel, rebuttal?
I hesitate to belabor any points. So I'll do something very out of character. If there are any questions from the court, I'm happy to answer them, but
Nope, you have nothing.
thank you.
Very good. Thank you so much. This case will be submitted. All right, next up, we have number 2, docket number 371584, People versus, and I hope if I don't pronounce these names correctly, please correct me because I don't like to mispronounce people's names. Xavier Lamar Lewis.
Morning, Your Honors. Michael McCarthy, P30169, attorney appearing on behalf of the defendant appellant Xavier Lamar Lewis. You pronounced his name exactly the way I understand it is.
Thank you so much.
I raised 2 issues in the brief of appellant that I filed in this case. I'd want to just to focus a little bit without repeating everything that I put in the brief about the first issue, which is the ineffective assistance of trial counsel. Different than the case that you've just listened to. There was no Ginther hearing in this matter, but that is because I didn't file a motion for that, simply because on its face, the things that occurred during the trial constitute, my argument is, the ineffective assistance of counsel. In the opening statement, the attorney representing the defendant
told the jury that this was consensual, that the sex act that it forms a basis for the conviction of one count of third-degree criminal sexual conduct was consensual. She would have known by that point, or should have known, that either the defendant is going to testify or she's got some other witness who is going to be able to give testimony to consent. But there was none, because the defendant did not testify. And in the appellee's brief, there's a statement, I believe it's on page 18. It says something, 14. It says, acknowledging this reality about the defendant not testifying, his appellate attorney seems to criticize defendant's choice not to testify. And that is not the case whatsoever. Your responsibility as a lawyer in a trial is to know your case, certainly by the time the case is called on the day of trial, and know what it is that you're going to do and what evidence it is that you're going to present. Now, if you're not going to call the defendant, that's a perfectly fine thing. But where is it that you're going to get this evidence to support a claim of defense? And what trial counsel argued when she tried to get 20.27 consent as a part of the instructions given to the jury, she says, well, Judge, I've been arguing it's consent the whole time. She didn't have an understanding of a basic trial practice rule, which is that evidence is a sworn testimony of a witness, or it's an exhibit, or whatever the trial judge instructs the jury evidence happens to be. What it definitely is not is the arguments of counsel or the questions asked by counsel. It's only the answers. Now, we all understand that, but this statement by the trial counsel in this case evidenced clearly a lack of understanding of the basic tenets of the laws of trial practice. And so he was prevented. The defendant was not able to have that defense. Now, the people also argued in the appellee's brief that the defense of consent is not available when you are charged with third-degree criminal sexual conduct where the complainant is incapable. And I just want to direct the court's attention to the use note that follows the jury instruction 20.27, which is a Michigan criminal jury instruction 20.27 entitled consent. And it says, this instruction should not be given where the victim is below age of consent, but it could be given where it is disputed at trial that the victim is mentally disabled or was physically helpless. So there was no concession that the complainant was physically helpless, and that was a question of fact for the jury to decide. And had consent, if some groundwork had been laid so that it could probably be given to the jury, that prohibition, because of the charge under which this case was brought, or the statute 750.520 C1D, I believe it is, or D1C rather, that still would have been available, provided there was evidence in the record to support the giving of the instruction. And that's what the use note provides for that statute, or for that jury instruction. So I submit that just on this alone, this whole idea of consent, there's ineffective assistance of counsel. And then the second point that I raised in there, in that issue, was this Cash App material that defense counsel just received apparently on the day of trial. She never showed it to the other side. And had she done so, had she raised this issue outside the presence of the jury and said, Your Honor, I'm tendering to opposing counsel this document that I just received today, and I want to have it admitted into evidence, maybe the judge would have agreed with the prosecutor, well, no, it's too late, you can't do that. Maybe the judge would not have, but we'll never know. That's all speculation, because it was never raised. And there was no proper foundation for the admission of this document. And instead, what happens is she just
put it in, the defense counsel did, and then it was stricken. So now it makes it look all the worse for the defendant. So those are the points that I wanted to make in support of issue number one. And in issue number two, that has to do with the assessment of 10 points for offense variable 19, which did change the minimum sentence range. When the jury finds somebody not guilty of a particular crime, the trial judge makes her determination that offense 19 should be assessed 19 points or 10 points because she went back and spoke with the jury afterward. And the jury apparently said something to the effect of, well, we thought he was guilty, but we acquitted him. That's not a basis upon which any judicial officer should make a scoring on the guidelines. That's something that, the jury speaks on a verdict or its inability to reach a verdict, but it doesn't, a discussion with the judge afterwards where people who voted 12 zip to find him not guilty now are telling the trial judge, oh, we thought he was guilty. And then to assess those points, I think that's just improper. And so that does have an effect. And I misstated in my brief. I said it was off by 4 months. The high end, or it was 4 months higher. It would have been. It's actually a 5 months difference between the 31 months that it should have been and the 36 that was given. So I'm here to answer any questions that you have. I have nothing more to say. Thank you very much.
Thank you.
Thank you so much, sir. This matter will be submitted. Very good. All right, we're moving on to item number 3. This is docket number 369129. People of the state of Michigan versus Jonathan Lamar Burks. Morning.
Morning, Your Honors. May it please this honorable court, Alona Sharon on behalf of the appellant, Jonathan Burks. I would just inform the court that Mr. Burks' father is in the courtroom today watching oral arguments. Your Honors, I typically appear for oral argument and anticipate responding to some of the prosecution's arguments, but of course, I don't have that opportunity today, given that the prosecution never filed a brief in opposition to Mr. Burks' brief. So we could just chat about the weather like Judge Feeney wanted to, or I'm just going to stress 2 points in the brief. I don't know what the absence of a brief reflects from the prosecutor's office. I don't want to make any assumptions, but I do just want to stress 2 points. One is, in the brief, I suggest to the court that I think initially this court may have denied Mr. Burks' application based on the case of People versus Motton, which was decided 11 days before this court denied Mr. Burks' original application to the court. Motton, of course, holds that Beck is not to be applied retroactively. And so I hope that I've made clear in the brief, and if not, I'm happy to answer any questions, that Mr. Burks is not seeking retroactive application of Beck. The brief does contain a very detailed outline of the procedural history in Mr. Burks' case. His original trial counsel preserved what I would call Beck-like objection because Beck didn't exist at the time of the original sentencing, arguing that OV3 couldn't be scored because it was based on acquitted conduct. The direct appeal preserved that challenge to OV3. He lost in the Court of Appeals. He then filed an application to the Michigan Supreme Court. While his application was pending, the Michigan Supreme Court issues an order holding his case in abeyance pending its Beck decision. And then after its Beck decision, the Michigan Supreme Court remanded back to the Court of Appeals. And the language was that his sentence was that the Michigan Supreme Court vacated the part of the judgment of the Court of Appeals addressing the defendant's sentence for home invasion and remands the case to that court for reconsideration in light of Beck. For some reason, when his case returns to this court, the panel refuses to address OV3 in light of Beck and chooses only to address the upward departure issue in Beck. And I would argue to this court that there is absolutely nothing in the Michigan Supreme Court's remand order giving a sort of a limit, I'm sorry, on what their consideration is. It's reconsider the sentence, right, in its entirety in light of Beck, which can be either the basis for the upward departure or the scoring of guidelines, because as this court knows, since Beck, there's a litany of cases, right, reversing offense variables based on Beck. So there is no block for Mr. Burks to seek relief from this court now. That's just one issue that I wanted to address because I think it's a little bit tricky, and I just want to make sure that the court's clear on the timeline. The other part that I just want to address, I do cite a number of unpublished cases in the brief. Of course, we're all aware that they are not binding. However, if they are factually very analogous, they can be persuasive to this court. And I do just want to highlight two of them, and that is the Amerson case and the Davis case. Of course, these are all cited in the brief and all attached as required under the court rule. I'll limit to Davis because I think Davis is really almost an exact copy of what happens here. Mr. Davis is charged with several murder counts, first-degree felony murder, premeditated murder, armed robbery, home invasion, possession of felony firearm. He is acquitted of everything except for the home invasion and the felony firearm. Despite that fact, he is awarded or scored 100 points for OB3. And this court, in reversing his sentence, has some very good language that I hope will direct this court. In that case, much like in Mr. Burke's, right, it's undisputed that there are victims who are killed, and that the pertinent question is whether Davis's conduct in relation to the home invasion was a factual cause of the victim's death, right? Which is exactly the same question we have for Jonathan Burks. And this court held that in light of Beck, we conclude that the trial court erred by assessing 100 points for OV3 when it scored the guidelines for the home invasion. The jury absolved Davis of any liability for the deaths of Welch and Newman. The jury's verdict acquitting Davis of the murder charges indicates that it determined that Davis's conduct was not a factual cause of the victim's death. There is no difference between this case. Yes, Judge Feeney.
I would ask you though, in this case, the trial court relied on pre-offense behavior. It was Mr. Burke's decision to invite a person to help recover the allegedly stolen property, if I'm remembering this correctly, who he knew had a penchant for violence and guns. And because Mr. Burks invited this person to come along, and Mr. Burks wasn't the shooter, I think he ended up being the driver. Because of that, it's like, what's the adage? It's like bring in a.
I know what you're talking. I can't think of
this kind of fight.
Yes, yes.
It was the pre-offense behavior that the trial court relied on, not the acquitted conduct. What's your response to that?
Sure. So I have two responses to that, Your Honor. OV3 is a McGraw offense variable, which means pre-offense conduct can't be considered. That's under McGraw and People versus Biddles. So I think that's why, respectfully, Your Honor, that argument doesn't fly. And I think, secondly, I don't think that there is a distinction between Davis and Mr. Burks, respectfully, because when the jury acquitted Mr. Burks of all the murder charges, right? First degree premeditated felony and assault with intent to murder, which was a few different charges of AWIM, right? It said, we do not believe that he had a factual causation in this death. That is the finding of the jury. And there's additional language in Davis, Your Honor, to support that. Is that, I'm sorry, not in Davis, it's a different order that I'll address in a moment, Your Honor. But when the jury acquits, so first you have the McGraw response, Your Honor. The second part being that when the jury found him not guilty, they found that he did not cause the death, right? It would have required factual causation. And when the jury acquitted him, that was them saying, no, he did not factually cause the death of Miss Montgomery. I think also, Your Honor, in response, and this came out like 10 days after I filed my brief in this case, there's an order from the Michigan Supreme Court, July 9th, 2025, in People versus Wells. The docket number, the Michigan Supreme Court docket is 167208. But if you look at the footnote in Wells, and this is an order, not an opinion, but if an order contains analysis, it's still binding authority. Footnote 2, in that order says, we note that the Court of Appeals has applied Beck in multiple published opinions on different facts in the last few years and reached the same conclusion we now reach, that resentencing is required when a trial court sentences a defendant on the basis of acquitted conduct. And it cites a number of cases. In reviewing the specific facts of this case, we hold that the trial court erred by sentencing defendant on the basis of an element of a charged offense that the jury rejected. And that's exactly what happened here, right? The jury acquits the causation of the murder of Miss Montgomery. And because of that, Your Honor, the scoring of OV3 is improper. That coupled with McGraw and Biddles, and that it has to be confined to the conduct of the charged offense, convicted offense, excuse me. Does the court have any other questions?
Yes?
Having that the court has no questions, I would ask that the court vacate the sentence for Mr. Burks, finding that the scoring of OV3 is in violation of Beck. I would also just note that in case the court, because I see this a little bit of inconsistency respectfully from the court, that because Mr. Burks received an upward departure sentence, that a incorrectly scored guidelines range is not a basis for the sentence to be vacated and remanded. And I would just note to the court, as cited in my brief, the Michigan Supreme Court case in People versus Jaber, which coincidentally was my case. Mr. Jaber received an upward departure sentence, but when the court found that OV5 was misscored, that he was entitled to have a sentence vacated and remanded, regardless of the fact that the court imposed an upward departure sentence. So the fact that there's an upward departure sentence is irrelevant if this court finds that OV3 was improperly scored at 100 points. Thank you very much, Your Honors.
Thank you very much.
Welcome. Oh, Your Honors, can I just take 30 seconds? I'm sorry. Attorney Matt Monahan originally represented Mr. Burks out of the State Appellate Defender Office, and he was responsible for a significant amount of the briefing in this case. And I do just want to recognize his work for Mr. Burks. At some point, it appeared that there may have been a conflict between the State Appellate Defender Office and Mr. Burks, and out of an abundance of caution, they sought new counsel for Mr. Burks, which is how I came in. But I would be remiss if I didn't acknowledge the significant amount of work that Mr. Monahan, excellent work that he did for Mr. Burks on this case. So thank you very much, Your Honor.
Thank you so much.
Thank you. And as I said, that case will be submitted. The next case, this is our fourth case in the docket number 373731, People of the State of Michigan versus Ricky Lee Hobby. Yes. Very good. Good morning. Can you hear us?
Yes, Your Honor. Good morning. John Roach, appearing on behalf of defendant appellant Ricky Hobby.
Very good. Go ahead, Mr. Roach.
Thank you, Your Honor. I want to thank the court for allowing me to appear via Zoom today. And I have taken the court's advice. I will rely on the brief presented. I am here today to answer any questions that the panel may have regarding the filings.
Questions? No. Very good. We don't have any questions for you, sir. We appreciate it. Thank you so much. We've read everything and we're all set to go.
Thank you, Your Honor. Have a good day.
Thank you so much. This case will be submitted. Very good. Turning next to number 5, this is docket number 373476, Tremaine Turner versus Acceptance Indemnity Insurance Company.
Good morning. May it please the court. My name is Kevin Kashad. I am appearing on behalf of plaintiff appellant Tremaine Turner. I respectfully reserve 2 minutes for rebuttal. Your Honors, this court should reverse the decision of the trial court for 3 main reasons. First and main reason is that a PIP carrier providing coverage consistent with the No Fault Act cannot limit its coverage to only accidents involving the insured motor vehicle. Second, even if it could, this policy, this company here did not do that. Their PIP endorsement is broadly construed. It's worded in a way where coverage would be afforded to Mr. Turner. And the third reason, Your Honors, is that to the extent that they allege that this portion does not state what it does, I would argue there's an ambiguity, and ambiguity should be construed in favor of Mr. Turner, who did not draft the contract and against defendant appellee. As for the first reason, Your Honors, it is well accepted that a carrier cannot limit no-fault coverage to accidents involving the insured vehicle. The trial court error stems from treating this policy, just reading it strictly contractual when, as we know, the No Fault Act has both statutory and contractual characteristics. To the extent that a contract conflicts with the statute, the contract must give way. Michigan courts have repeatedly held in Cruz v. State Farm, Andari, and Lee that personal injury protection benefits are statutorily mandated. They have statutory and contractual characteristics. Policy language is enforceable only to the extent it does not conflict with the act. Here, acceptance admits that its PIP policy contains PIP coverage issued pursuant to MCL 53101 and provided consistent with MCL 53105. Once that concession is made, entitlement is governed. It's governed by statute, not by limiting contract language. This is a situation where we are seeking PIP benefits pursuant to MCL 53114 subsection 1. In that situation, you look to whether you are a named insured, spouse, resident relative. Mr. Turner is undoubtedly the named insured on this policy. They do not dispute that. We don't look to some of these other cases which reviewed and ordered priority under 3114 subsection 3, which is an exception, as is subsection 2, subsection 5 for motorcycle accidents or accidents involving a vehicle for hire. The relevant section here is 3114 subsection 1. And the main case I would like to direct Your Honors to is the Member Select versus Hartford case. I think it's exactly on point here. In that situation, you have a commercial carrier who tried to say, we limit our policy, our coverage only to accidents involving the insured vehicle. That was an accident that did not involve only the insured vehicle. This court in a published decision said that this policy must yield way to the statute and coverage must be afforded by that commercial policy. The fact that this is a non-trucking or bobtail policy is another commercial policy. There is no exception outlined by the legislature for commercial policies, bobtail policies. They have to afford coverage consistent with a personal policy under 3114 subsection 1. As Mr. Turner is a named insured, he's entitled to seek benefits from the acceptance policy. None of the exceptions apply here. And if the exclusion was enforceable, a named insured could hold that a PIP policy, or with a named insured could hold that a PIP policy that has coverage would not receive benefits if they were a pedestrian, a passenger, or a driver of another motor vehicle, which is not what our lawmakers intended. Moving on, Your Honors, I do want to just mention that appellee cites MCL 257.520J, which is part of the Motor Vehicle Financial Responsibility Act. It does not modify the No Fault Act. It does not create PIP exclusions. It does not override 3114. I believe based on that reason alone, the decision of the trial court should be reversed. However, if the court wants me to move on, assuming arguendo that a carrier could do that, as I mentioned previously, this PIP endorsement is read broadly. It says that we will pay benefits to an insured injured in an auto accident by use of an auto. It goes on to define auto as a motor vehicle. It does not limit the coverage to only the insured motor vehicle in the endorsement. And as I mentioned earlier, to the extent that their position is that it does, I think it is ambiguous, and I would ask this court to respectfully reverse the decision of the trial court. And if there's any other questions, I'd be happy to answer them.
Anything?
Thank you, Your Honors.
Thank you very much. You've got plenty of time for rebuttal.
Thank you.
Morning, may it please the court, Christian Huffman on behalf of Defendant Acceptance Indemnity Company. I did the best that I could to address all of plaintiff counsel's arguments in my brief to outline my client's position. I have not gotten any smarter since I wrote it, and I could not think of anything that I didn't put in my brief to say today during oral argument. So if it's okay with the court, I will rest on my brief. If the court has any question, I can try and answer them, but
Counsel is pretty direct in saying that you can't just limit it. If you offer it, you can't limit it to that vehicle because what's the terminology? PIP applies to people, not vehicles.
my client is of the belief that this court's decision in the integral case, which involved semis like this one, permits it to do so. Member Select decision did not address the integral decision or overrule it. I explained in my brief, that is what my client was operating under when they made this decision.
Okay, so still, when you get to the point of no fault, PIP benefits are to cover people, not vehicles. Just in 20 words or less, tell us why. Nope, that's wrong. It covers vehicles, not people.
Because, as I said, the integral decision says that they can put a provision in their policy saying we will provide the PIP for this vehicle. You have to purchase PIP for other vehicles from another insurer. Of course, decision and integral is there. So that is what they've been operating under. Thank you.
Thank you. Counsel, any rebuttal, please?
Very brief, Your Honors. As I mentioned in my brief, the integral decision involved in order priority analysis under 3114 subsection 3. I deal with trucking cases quite often. They are a lot of fun. I'm joking.
I was gonna say, yeah, tongue in cheek.
But nonetheless, the only other thing I forgot to mention, Your Honors, is I do just want to bring the court's attention. There was another published decision that came out on October 30th, 2025, docket number 368902, which dealt with this court finding that policy exclusions were invalid when a carrier tried to rely on them to not provide PIP coverage consistent with the act. That is it, Your Honors. I have nothing further unless the court has any other questions.
Anything? No, thank you so much.
Thank you, Your Honors.
Thank you both. This matter will be submitted. Very good. Number 6. This is docket number 372-826. Emily Fossmore versus Callie Ann Raw. Callie? Okay. I'll leave it to you to figure out.
And good morning, Your Honor. Rick Samansky for defendant farmers in this matter. Judge, I'll keep it brief because I think the facts are generally not in dispute in this matter. Plaintiff Emily Fossmore was involved in an accident back on June 8 of 2023. She was a passenger in her friend Kaylee Roth's vehicle when the accident happened. When the accident occurred, she was domiciled with her mother, Jane Fossmore, and at the time of the accident, her mother had a policy of insurance through Progressive. Of course, they are attempting to rescind that policy, or I should say, have rescinded the policy as to Ms. Fossmore, and they attempted to rescind the policy as to plaintiff in this matter. I know Progressive goes through a lot of effort to justify their decision to rescind the policy to their insured. We're not disputing that. We have no position on that. It's our position, though, that the trial court improperly analyzed the facts in this matter under the Bozzi Pioneer factors in determining that the rescission should be extended to plaintiff in this matter as a third party. And I'll just touch on the factors very quickly. First is the extent to which the insurer could have uncovered the fraud. In this case, Progressive and the trial court focused on whether or not the insurer had a duty to uncover that fraud. And that's misinterpreting the factor. Here, they certainly could have done any investigation they wanted to determine that fraud. And indeed, they did discover it shortly after a claim was made. 2 is the relationship between their insured and the third party to determine if the third party had some knowledge of that fraud. In this case, based on the depositions of the plaintiff and her mother, there's no indication that she had any knowledge that her mother had committed any fraud. There seems to be some conflicting information as to whether or not she may have known that her mother had an insurance policy. But
I thought she paid her, I'm sorry to cut you off. I thought she paid her mother money to go toward the no fault policy.
Your Honor, I believe that she testified at some point in time. It wasn't clarified whether it was this Progressive policy or another.
Okay.
She thinks she may have given her mother some money for a policy. But hypothetically, even if she had given her mother some money for the policy, that doesn't show that she had knowledge of the fraud committed by her mother. I think her mom specifically said she had no knowledge of it. She didn't help me with it. She didn't provide any information. And so there's no evidence that the plaintiff had any knowledge of the alleged misrepresentations. Third, with regard to the nature of plaintiff's conduct, whether it was reckless or negligent, again, she was a passenger in a friend's vehicle. I know that the trial court kind of hung on the fact that she had consumed some alcohol in the day, but there's no evidence that they were intoxicated or that the plaintiff knew her friend was intoxicated when she got in the car. I don't believe there were any criminal charges that resulted from this. And so I don't think there's any evidence that she was reckless or negligent.
What's the trial court trying to say that she should have gotten out of the car while the friend was driving 90 miles an hour drunk and recklessly?
That's very possible, Your Honor. I can't surmise.
Yeah, and that's what, going through the factors, I'm like, did you expect her just not to get in the car? But she got in the car. But then I didn't see a point at which it was feasible for her to get out of the car.
No, Your Honor, it sounds like the driving was very erratic and dangerous, and I
Okay.
think there would have been an opportunity to. Either way, there was no evidence regarding it.
Okay, I thought I missed something, but anyway, like they stopped to get a bite to eat and she could have just like left then or something. So, okay.
Your Honor, the fourth factor is the one that I really want to hit on here, because I think this is the one that, quite frankly, we're seeing a lot in these rescission cases, where all of the other factors weighing against rescission being extended to a third party, the insurers and indeed a lot of courts are hanging their head on the fact that, well, the MAIPF is here, so you can just automatically go to the MAIPF. We should allow rescission. I don't think that's proper to give the fourth factor undue weight for several reasons. One, from a public policy perspective, allowing insurers to rescind just because the MACP is there goes against public policy. The MACP is obviously here to be the insurer of last resort, a safety net. We should not be here to catch everybody when an insurer decides they want to rescind the policy, whether justified or not, just to avoid their obligation to pay PIP benefits. I also listed numerous unpublished cases that stand for the proposition that the fourth factor should not be the determinative factor. Again, that tips the scales in favor of rescission every single time where the MAIPF is available. And finally,
Well, unless it's more than a year past.
that could be, Your Honor, but in this case, that's not the case. Finally, as we point out, Progressive does have a route to recovery that the MAIPF does not have, in that if they're required to pay PIP benefits to or on behalf of plaintiff, they can initiate a fraud claim against their insured who made the fraudulent statements. I believe that was pointed out in the Van Dyke spinal case, indicating that that should weigh against extension of rescission. And I believe the fifth factor does not apply to this case. All that being said, Your Honor, I know at the trial court, both plaintiff and Progressive conceded that of the five factors, basically only the fourth one weighed in favor of rescission. I know they have now reversed their course, but I think given the evidence in this case, extending rescission to a plaintiff was simply inappropriate. And with that, Your Honors, I'd be happy to take questions.
Anything? Very good. Thank you so much. You have plenty of time for rebuttal. Good morning.
Good morning, Your Honors. Andrew Malik on behalf of Defendant Progressive. I will similarly keep it brief and address a lot of the arguments that were made to you just now. So we would like this court to affirm the trial court's decision to extend the rescission of the contract to both Jane Fosmore and Emily Fosmore. And going through the BASI factors, we do believe that they weigh in favor of rescission. So the first one, whether or not Progressive had the ability to uncover the fraudulent statement. I do think that the insurer's ability and their legal duty at this stage in the application are intertwined. But in this case, there was really nothing that would have triggered Progressive to know that there were any obvious discrepancies in the statements that that Jane Fosmore made in her application. She certified her representations that she was the only member of the household. There was really nothing else that Progressive would have at that time during her application to know that something was wrong. And I think a lot of there are cases where there are obvious discrepancies, right, with what the applicant is saying and, the information that an insurance agent might have. But here she's filling out her application or she's talking to an insurance agent and, telling them I'm the only member of this household.
But was it an agent actually? Because if you're just filling out the forms online, that's different than talking to an agent.
Sure, it is. I believe in this case, it was a form that she filled out for her application. But even if she were speaking with an agent directly, if the agent is asking her to list the members of her household and she lists them as one member of the household, the insurer has a right to rely on that representation that there's only one person there.
Wouldn't that factor then always go in favor of the insurance company? I mean, ultimately, and I forget which case it is, but they could have just ran, they didn't have a duty to run a, Secretary of State search, but they could have run a Secretary of State search and discovered that there were multiple people that were registered to that address. And so, if we just accept that they don't have a duty to it, then why even have that factor? Because it would always go in favor of the insurance company. And rather here you have the insurance company who could have run it. They chose not to because they didn't see anything questionable. But then you have this innocent kind of third party, and that's the balance that the court has to weigh. I mean, who is in a better position to, I guess, uncover that fraud?
Well, I think there's a couple of points I'd like to make to that question because I think it's a good question. I think the applicant is in the best position to provide accurate information so that the insurance company can provide that applicant with the proper coverage and issue a premium that is appropriate based on those representations. I also think it's important that, when they mentioned that they uncovered the fraud shortly after the fact. I think, the accident took place in June of 2023. It wasn't until a month later that they actually sent the correspondence saying, hey, we did an investigation. We found out that these representations were false and we're rescinding the policy and it's void. So it wasn't a super quick turnaround, a day later for them to send that correspondence. The correspondence was dated in, I believe, July.
Yeah, but this, I'm looking at Van Dyke Spinal. In that case, it was the same sort of thing. They very quickly were able to do it, but they received additional premiums and everything else. In this sort of situation, isn't it incumbent upon the insurance company? Again, there's no duty, but they should run just the address. Run the address. Who else is showing up there? And that's all they had to do. That's it. Say, oh, wait a second. We gave you an insurance policy, but you need to be paying 25% more because you have two other adults in that house who are living there and could possibly be using this. I mean, come on, there has to be something based upon Van Dyke that the insurance companies need to be doing.
And I understand there are instances where that could be the case. And again, these are balancing factors. So it's, not all on this one factor.
But Judge Bazzi's point is well taken, that if you just say, well, we always have to rely on the people who are filling out these forms, not talking to an insurance agent, just filling them out online, maybe they don't understand, you know what I mean? That this will always go toward, oh, well, they didn't tell us and we had no idea. And so, factor one will always go in favor.
I don't think factor one will always go in their favor because I think there are instances where there are obvious discrepancies which were not present in this case.
Okay, so tell me how this case differs from Van Dyke Spinal Specialists.
Well, I think in this case, the insurance company, they were relying on her assertions in her application.
Every insurance company does. So how is this different than Van Dyke Spinal Specialists?
Well, I will concede that there are a list of other things that an insurance company could do. But I don't think, and this is where I think the legal duty kind of comes into this factor. They don't necessarily have to do them. But there are, I'm sure a list of things that could be done. I think that would have negative implications for the insurance industry as a whole, for the insurance company to, at the application process, undertake a lengthy investigation to.
Okay, so Van Dyke Spinal Specialist, this case, simple one thing, run the address. That's not a lengthy investigation. Same thing in Van Dyke Spinal Specialist. There was a very simple thing they could have done and they didn't. So again, I'm trying to see if you have a good way to distinguish the analysis that was done in Van Dyke Spinal Specialist from this case.
Well, and I agree that they are similar cases. But again, I would just go back to, there are a list of things the insurance company could do, and maybe running the address is one of the things that they could do. But then bringing in their legal duty, I don't think they have to do it. So that would be my answer to that question. And I do think there are instances where this factor certainly would not weigh always in favor of the insurance company. Going to the second factor, in the familial relationship, this court has held, and it was in Farm Bureau versus Ace American Insurance Company, that a close familial relationship does allow for an inference that the third party knew of the fraud. And in this case, I do think there are other facts that support that inference. Your Honor mentioned the fact that she did at some point pay for the insurance that her mother had.
Doesn't that actually work against that point though? Because she thought that she's giving her mom money for the no-fault insurance that she believed her mom had her listed as.
Well, I think it would lead to an inference that, right, that she would be knowledgeable of the insurance policy and the fact that she was not listed on the policy.
How does that equal? I guess that's my problem. So I'm giving my mom and dad money. I'm living with them, right? And I'm living with my folks and I'm giving them money for the no-fault insurance. By giving them money for the no-fault insurance, doesn't that argue in favor of the fact that I believe I'm on their insurance because I'm giving them money for it? It doesn't go to, I think I'm not on their insurance, but I'm giving them money knowing I'm not on their insurance. I don't follow you with that.
I think it, and I understand what you're saying. I think it lends support for the fact that she knew that there was insurance and would have known what the coverage would have been in that case. I don't think the fact that she was paying her mom for the insurance necessarily means that she knew that she was listed on that policy.
But wouldn't it go to the fact that she believed that she was somehow included or benefited from that policy? I mean, that's why you give them money to pay off something that you're covered under.
She may have thought that she benefited from the policy, but that doesn't mean that she knew or thought that she was listed on the policy. But again, that close familial relationship, she knew that, and she even testified too that she knew that her mom obtained insurance 6 months prior. So again, I think these things all kind of lend support for the fact that she knew that there was a policy in some way, not necessarily that she knew that she was listed on the policy. With regard to the third factor, I understand the concerns on this factor, but I do think it does support rescission. Both her and her friend, or she testified that she and her friend both consumed about 8 ounces of alcohol, along with some other alcoholic beverages, and that was earlier in the night before they got into the vehicle. She knew her friend was driving erratically. So I do think that one weighs in favor of rescission in terms of her role in the event that took place here.
Well, she knew her friend was driving erratically once her friend started driving erratically. It's not as if she knew her friend was driving erratically when she entered into the vehicle, which would be factually different. Is that correct?
Yes, but she still knew that they were consuming alcohol before the event took place.
Which makes people make really good decisions, doesn't it? I mean, that's the point when I asked counsel, and can you point me to a part in the record that shows that she had the ability to safely exit the vehicle once her friend started driving erratically?
There's no part in the record as to that detail, but I think the fact that they drank beforehand and still drove.
Which every single person who gets a drunk driving conviction does. So it's not like drinking made her clearer of thought, right?
No.
But that's the whole thing. So the only way, I think, given what Judge Bazzi was saying and what the judge said, was you did not get out of the vehicle. I think that's what the judge said specifically. You didn't get out of the vehicle once she was driving erratically. So I'm trying to figure out, there must have been a point at which she had the ability to get out, as opposed to 80, 90 miles an hour and open the door and do like a roll like MacGyver or whoever does when they get out of speeding cars.
Right.
But you're saying that there wasn't that opportunity. It was just, don't get in the car with somebody who's been drinking.
And I think that is a legitimate, I think that is a legitimate concern or a legitimate point that you shouldn't get into the car after you've consumed that level of alcohol and
But-
started driving.
So that means that rescission will happen whenever there's a drunk driving situation going on.
It's not whenever, again, they're balancing factors, right? It's not one is necessarily more than the other.
Okay, you'll always lose factor 3 if you are a drunk driver.
I believe it would weigh in favor of rescission in many cases. Depending on the facts of that, I think on this one, it does weigh in favor of rescission. Given the fact that she specifically testified that they had consumed 8 ounces of alcohol and it was 3 to 4 White Claw beverages as well beforehand. And the fact that she testified that her friend was driving erratically. So I think in this instance, it does weigh in favor of rescission. But again, they are all balancing factors, so it might not always be that case. And then again, briefly with the fourth one, we would agree with the trial court. There are alternate means of recovery through MAIPF. And in this case, the recovery would be actually greater than recovery through Progressive, given that the Progressive policy that Jane Fosmore took out is for $50,000 versus the $250,000 through MAIPF. And going back to the other point that was made, I do believe this was a legitimate reason for, rescinding and voiding the policy based on a material misrepresentation of Jane Fosmore. I don't think anybody's disputing that it was a material misrepresentation. There are portions of her policy that specifically state, if material misrep is made or fraud, the policy can be rescinded and deemed void. Ms. Fosmore also had a duty to report changes under her policy. So if it, were the case that she wanted to make the changes and add other people to her policy, she had that continuing duty under the language of it to make those changes. So we're requesting that this court affirm the trial court's decision. And if there are any other questions.
Anything else? Thank you. You're all set.
Thank you.
Good morning, may I please escort John Knockhazel on behalf of plaintiff appellee Emily Fosmore. 2 quick points, and then I'm happy to sit back down. Is one, I don't think it matters that MAIPF is the appellant here. I think if it was any other insurance carrier with a 250 or unlimited policy, my argument would be the same thing. And basically, it's that Progressive in this case only has a $50,000 PIP policy. You can only get a $50,000 PIP policy if everyone in the house has Medicaid or qualifying health coverage. Emily did not have Medicaid or qualifying health coverage in this case. Therefore, if we go to the MAIPF policy, we can get her the $250 in coverage that she needs. She's got that much. She has more than $50,000 in damages. She needs the additional coverage. So just looking at that factor, balancing the equities, I don't think it's fair to say the trial court abused its discretion solely on factor 4. And I think you can make a distinction from all the unpublished case law that they cite, because none of them have dealt with this scenario of reduced coverage if the rescission isn't upheld.
That's kind of a unique situation.
It is.
I would have to say. But I've had a couple of cases where it's been like that. And because the person who got the insurance selected the 50,000 and, assigned claims offers you the 250.
Right. Well, there's cases that they're the opposite way around, where they might have unlimited and then the assigned claims only is the 250.
Yeah,
And I'd be arguing the other way.
exactly.
And that's how the equity is balanced in this case.
Anything else?
Appreciate it.
Thank you so much. Counsel?
I think you're absolutely right. There is much more that Progressive could have done to uncover the fraud in this case. And in fact, we see it regularly from insurance companies between running Secretary of State searches, people searches. There are systems now where they can use cameras to determine which cars are being parked at which house. There's a lot that could have been done to uncover this fraud. They simply chose not to. With regards to the Ms. Fosmore's knowledge of fraud, I think that everything that Progressive has pointed to requires a lot of speculation and would require us to draw inference. I think most of us know that our family members have insurance, but simply knowing that insurance is there does not mean that you have some knowledge of the fraud. And then finally, with regards to the difference between availability of recovery under progressive versus the MEIPF, that is there. All I would say is that the legislature drafted our No Fault Act in the way that they did, and they allowed individuals to select lower amounts of coverage. And the statute specifically says that coverage selection applies to family members, and that's what the legislature intended. When we're making an equitable determination like this, the court is essentially weighing the equities to determine who is the more innocent of the two parties between Progressive and Ms. Fosmore. And what plaintiff is actually asking the court to do is find that Ms. Fosmore was less innocent, such that rescission should be extended to her so that she can collect more. And I don't think that comports with the principles of equities. That's all I have, Your Honors.
Anything? Thank you so much.
Thank you.
That case will be submitted. We're going to take our brief break before we start our 11 o'clock cases. We're not too far off. It's only 11:30, so we'll be back about 10 minutes or so.
All rise.
Welcome back, everyone. Thank you for your patience. And as everyone knows, if you have any cases involving minors, I'm trying to think if we do in our 11 o'clock call. Yes, we do. So please don't use their names, use initials or something along those lines with that. So, all right, here we go. This is number 7 on our call. This is docket number 376734. And I want to make sure I pronounce this correctly. Brianka Dean versus Craig Hunter Jr. And I believe Mr. Hunter is here for questions only. He's appearing by video. And then Miss Dean. Mr. Hunter, can you hear us?
Yes.
Okay, very good. And Ms. Dean, you're representing yourself today?
Yes, I am.
Very good. And you've got 15 minutes.
Okay, my name is Brianka Dean, appellant of this case. This appeal challenges April 7th, July 2nd custody order and June 3rd evidentiary hearing. I'd like to address that my child's best interest was not analyzed properly. An established custodial environment was disrupted, and due process concerns and also UCCJEA forums concern as well. I would like to address. The trial court altered an established custodial environment, suspended my parenting time as my daughter's primary parent, and did so without applying proper legal standard. April 7th hearing was requested March 26th after my daughter, after he exercised his first visit with my daughter in 2 years. And during that visit, he refused all communication. He refused to return her, and he filed for emergency full custody during that time as well. Once my daughter came back from the visit March 10th after a hearing that was held for her return, she came back abused and traumatized. I took my daughter to the hospital. I filed the police reports, and I contacted CPS. March 26th, that's why I filed for it to modify the parenting time order. And that hearing was scheduled for April 7th. April 7th, he also filed for emergency full custody again. That day, I was not served with that or given opportunity to respond to his motion.
Weren't you were anticipating the hearing on April 7th, right?
Yes, I was anticipating that hearing for the modification due to the abuse concerns.
All right. And was the emergency motion an ex parte motion? Which means they could do it without giving you notice? Do you know?
I wouldn't say so.
Okay. So, but while you were there at the hearing and you guys are both there virtually?
Yes.
Am I recalling? All right. So the court informed you verbally that this was the motion for emergency change of custody that Mr. Hunter had filed.
Yeah, so after I spoke, he said that he had filed an emergency full custody and that would be addressed. My concerns about the abuse was basically denied as insufficient. And he was granted emergency full custody right then and there on the spot.
And that was appearing in front of the referee, correct? Okay. Can I ask you that, we don't have a transcript of the hearing at all. Did you ever request one? I know that, you know,
I didn't request one.
and at that hearing, was it on like a motion day where everybody was there for their motions and you kind of go up one after another? Or you guys have appointment times for motions?
No, I wouldn't say.
All right, so was it just a date set for an evidentiary hearing?
April 7th?
Yes.
April 7th was, you said, was there a date set already for evidence hearing?
Yes.
I believe so. But an evidentiary hearing was set before because I was already filing motions prior to the first visit and everything because of my concerns for her, my daughter, because I was already scared of him having her and him being abusive and stuff like that. So he was already using the system against me. He was basically saying that I was withholding my child from him without ever trying to exercise a visit. So I was going back and forth to the court to letting them know that he's filing against me without trying to exercise the visits and basically using an order against me. So they set that evidentiary here for March 26th, but he still was granted the 8 days for the first visit that he exercised.
Can I go back to April 7th just real quick? Did both of you have a chance to testify? They swore you in? And did they swear you in? at
April
that hearing?
7th?
At April 7th?
I'm sure we did to
Okay.
speak to.
Okay. And then did you get a chance to like present your evidence and he get a chance to present his evidence?
So no, I once I filed my motion, I filed along with that was the records from the hospital. So the diagnosis from the hospital, and that was a sexual assault.
Well, that's what you reported, but there was no diagnosis of that. It was just what you reported. There was no findings consistent with that. But what I'm trying to figure out was on April 7th, did the referee go through what we know as the best interest factors? There's 12 of them. Did the referee go through and make findings after the referee talked to both of you?
No, not at all.
Go ahead. I'm sorry.
So he was granted full custody then April 7th. My parenting time was suspended and my future hearings was to be in person only. I objected to that as well, but since I felt kind of blocked from the court because I didn't have the means at the time to continuously go back and forth to court with my daughter to travel to Michigan. We live in Georgia. I would have to get lodging, rental, and more things to travel out here. So fast forward, June 3rd was the evidentiary hearing. That was also in person only as well. I wasn't given notice of that hearing either. Also, that was he only gave his side. I will say that the best interest was kind of like the fact that it was thrown over, like run over. It wasn't fully analyzed what was best for my child. And it was also further transferred to full permanent full custody to him. My parent time was suspended further, and it was the contact with my child was based on a psychological evaluation, which I did do, and it found me fit and no issues to parent my child.
When was that done? Give me the date.
Of the
When it was filed with the court?
It was filed with the court November 17th of 2025.
Thank you.
Oh, I'm sorry. It was filed before that. A hearing was held on it November 17th.
Got it. Thank you.
Also, So my daughter was returned with him, I want to say June 5th of 2025. That's once okay, I'm sorry. For June 3rd evidentiary, I filed the objection timely. I was basically refused to be to I was denied to speak on my objection. I was told that the review of that objection would be conditioned on my ability to pay for the transcripts of that evidentiary hearing within 7 days of the order being issued, which I did. I paid for the transcripts within that 7 days. However, it was still entered as final anyways. Um, that was on July 2nd's order. Since then, I had little to no contact with my child, and I've been refused to parent my daughter.
I thought that the court offered those to you and you said no.
So June 30th, that was the hearing. That was July 2nd order, what it has stemmed from. During that hearing, I was there for the return of my child. Also, the objections was basically talked about and everything. But during that time, she offered for me to visit my daughter at a Michigan facility the very next day. I had a flight out that same day, and but I still felt that it was no reason to basically require those type of restrictions, and me being the primary parent of my daughter.
But you were offered parenting time and you refused it because you didn't want to be super.
I didn't want it to be at a facility. I felt that that is a traumatizing thing, even though everything was being going through right now is a traumatizing situation.
Last time you saw your daughter?
Christmas, I drove out here to see her. He brought her out for maybe 5 minutes, and I gave her her gifts.
December 2025.
Brought her her gifts and gave her a hug, and that was it. Since then, he won't allow me to see her. Calls, he monitors every call. My daughter is not able to speak freely on the phone. My daughter is begging to come home. She continuously asks. She said that she's crying at school. She's crying to come home, and
Enrolled in school. Was she of age when you were in Georgia to be enrolled in school?
she was 3. She had just turned 4 April 3rd, so she would have been enrolled in school that following.
But you didn't
school
have
year.
her enrolled in school because she wasn't old enough to be enrolled in school in Georgia. Okay.
His first visit with her was that was the first visit that he exercised within 2 years, and prior to us moving to Georgia, he was basically inactive in her life.
Is there a reason that you didn't keep the agreed upon parenting time schedule immediately after you moved to Georgia? Because you guys agreed to it.
No, so after I moved to Georgia, there was they set a date for him to get a new parenting order. So that was that was April 2nd for that hearing, because it was right before my daughter's birthday. So April 2nd, that was the evidentiary hearing. It was never set. Once I moved, so I had went to court and I requested the relocation. That order came back, and it said that the regular parenting time will be still enforced up until I move. And that was the case, even before he wasn't exercising that parenting.
But I thought that you guys agreed once you got to move, and here's the agreement regarding parenting time. Isn't that right?
No, there was no agreement put in place.
So the court was just wrong about that.
Correct. There was no agreement put in place. After we moved, a few months later, I received notice that a hearing was scheduled, and that was scheduled for April 2nd. And he was granted another parenting time for every weekend, well, one weekend a month. Once we received those orders of his new parenting time order, I texted him, said, let's set up a visit. He ignored me. And that same week, he filed against me, said I was withholding my daughter from him.
Did you just have to use like Our Family Wizard or some other application app where you had to communicate through it to show that I communicated, they didn't respond, that sort of thing?
I showed basic text messages, though that app wasn't presented to us until later on into the case. So I did present evidence showing that my efforts in the communication with him was refused.
All right, so there was one visit before you saw what you thought was alleged abuse, right? There was only one visit.
Yes, it was only one
Okay.
visit. So she was there. It was supposed to be from February 23rd to March 3rd. He refused to return her. He refused communication throughout that visit. And he also filed a PPO on me March 3rd as well. That was granted. No evidence or no threat or anything that was done to him, however.
And did you challenge the PPO?
Yes, it's still pending in the appeals court as well.
Oh, but so you challenged the PPO, it was upheld, and you're challenging that on appeal.
Yes.
Thank you. Okay.
So March 3rd, so then I filed to have her returned. That hearing was scheduled for March 10th. The judge, she returned my daughter, with condition that she would review his full custody motion if I didn't return her for a second visit. That was April 3rd.
I have a question for you. Have you undergone the evaluation that the trial court ordered to reinstate parenting time?
Yes, I did.
You did do the
psychological
evaluation?
Yes, I did. The evaluation concluded that there's no reason to restrict parenting time, or I'm not a danger to my child or a risk to myself.
Is there anything else the court asked you to do?
That was all. It was just that, and then once I presented the psychological evaluation, I requested that that my parents' time be reinstated. During that hearing, she basically she refused. She said that she's not going to relitigate that. She's not going to relitigate me reinstating any parenting time because it was already established during June 3rd evidentiary hearing.
Did you file that evaluation with the trial court?
Yes. So that was heard for November 17th, but it was basically brushed over, and she basically said that I will get 2 hours a month at a mental care facility and one phone call a week with my child.
You do phone calls now?
It's ordered for one phone call a week, but I do talk to her a little bit, but he still monitors every call, so my daughter's not able to speak freely or to say.
She's
really
how old
she
now?
feels.
4?
Yeah, she's 4.
And you can tell she can't speak freely at 4.
Yes.
4-year-olds that I know speak pretty freely.
Yes.
So
Yes. So yeah, I know when she feel restricted, and
she tell you she feels restricted?
I can see it in my child.
But
yeah.
you're talking to her on the phone or you're on like FaceTime?
Both, either or.
Okay, got it.
Either or.
Okay. That's about all the time we have. Any other questions? Anything else?
I don't think so. If I do, I'll ask on rebuttal.
Very good. All right. And does anybody have any questions for Mr. Hunter? Because
I do.
Go ahead.
Hi, Mr. Hunter. I want to know from your perspective whether the referee went through the best interest factors on April 7th. I note that the referee's recommendation indicates that the referee did, but I want to know from your perspective if you think that they did.
Yeah, I think everything was presented right and and placed in order for everybody to follow the right directions to do the right thing or whatnot.
Maybe more specifically, Mr. Hunter, were you and Ms. Dean at the hearing on April 7th?
Yes,
Okay. And did the referee do what the referee did for other hearings, which is swear the two of you in?
yes,
Okay. And did you have a chance to present your evidence and Ms. Dean have a chance to present her evidence to the referee?
yes.
How long did the hearing go?
Um, that day or just period?
April 7th. That's all I'm concerned about.
I don't know. It could have been 40 minutes, an hour.
Okay. Does that sound right, Ms. Dean?
No, I think it was maybe like 20 minutes.
Okay.
15 minutes.
Versus 20 minutes. All right. And do you know, Mr. Hunter, what I'm talking about when I refer to the best interest factors?
Yes.
What am I referring to?
The best interest on who should have the child, right?
Yes.
Yes.
And I think that in the opinion, and the June opinion, the referee went through them, which is, oh, for heaven's sakes, I've got it right here. So, for example, the love, affection, other emotional ties between the parties involved in the child. That's A. The capacity and disposition of the parties to give the child love, affection, and guidance, and their ability to continue the child in their religion or creed, if any. That's B. The capacity and disposition of the parties to provide the child with food, clothing, medical care, and other remedial care that's required. That's C. Do you remember at all the the referee going through all of those factors, 12 different factors, and making findings that you're preferred, that Ms. Dean is preferred, that there's no preference under these factors? Did the referee do that on the record?
Yes.
And did you ask for a copy of that transcript?
No, I didn't.
Because I'm trying to figure out why, if the referee did all that on April 7, why the referee then scheduled an evidentiary hearing for custody to be on June 3rd. That makes no sense to me, because already the June 3rd hearing was set for parenting time and child support, correct?
Yes, I believe so.
Yep. And then the referee on April 7th said, we are going to set this for an evidentiary hearing on the same day as the hearing you already have set for parenting time and for child support, right?
Yes.
Because if the referee already went through everything at the April 7th hearing, there'd be no reason to do it again on June 3rd.
Was it because the June 3rd hearing was already scheduled?
I don't think,
The June 3rd was already scheduled. The parenting time and the child support were already set for a hearing, correct, Mr. Hunter? Ms. Dean is nodding. Yes.
yeah, I'm not sure because I know I was supposed to have my daughter on her birthday,
Okay.
which was the 3rd, and I didn't was able to get her because she denied me.
Yes, but I think that what happened was, and you filed the motion to enforce your child visitation. And the court set the June 3rd hearing, which was out after her birthday happened, and you didn't have her. They set that hearing for parenting time and child support. Does that sound right?
Yes.
So then on April 7th, when the court said, okay, all these things, and we're going to set this for a hearing on June 3rd. We're going to have you go and have this hearing. So to go through custody as well as parenting time. Does that sound right?
Yes.
Yeah, because it says the issue of custody shall be referred for referee evidentiary hearing to be combined with the already scheduled evidentiary hearing regarding parenting time and child support before referee Wright on June 3rd, 2025 in person as previously noticed, right?
Yes.
Okay, so Ms. Dean, you got that order. You got the April 7th order and it said that date of the hearing and you still didn't show up, right?
It did have that on there.
And so it said that's the date of the custody hearing and you still didn't show up because it was already scheduled for parenting time and child support. And is it, you just couldn't afford to make it there, or?
Couldn't afford to make it there. And then also the April 7th order, I didn't scan through to actually see.
But you should. These are your orders. I mean, and I have a hard time believing that because the two of you have filed more motions and responses to motions and then follow up even on the same day. I mean, I did family law for 22 years. I never saw anybody file motions as quickly as the two of you have done in response to each other's motions. So So I can't do anything when the order itself clearly states, and it's like in bold, like in person on June 3rd. So, all right.
I'm sorry, but I objected to it, even though I couldn't afford to make it there in person with me and my daughter. But I still objected to it timely and made sure that it was put on record that I couldn't make it and that I wanted to at least be heard on that situation.
But did you file anything? So, for example, sometimes when people couldn't physically be there in person and they knew they were going to be going through the best interest factors, they would submit something in writing. You didn't do that either.
No, I did not.
Okay, all right. I don't have anything else. Anything else?
Not that I don't think so.
Anything else? Very good. Thank you so much. We're all set. This matter will be submitted. All right, the next one is number 8. This is docket number 375-839 and Ray LD. Is it Lester? Minor? Very good. I'll just note that this was set on the 11 o'clock call and it's now 12:19. I'll consider this case to be submitted. And then number 9, docket number 373-356. And Ray Alexander /Lee/Cantu/Thomas Miners. Sorry about that. I saw you get up and then sit right back down. So
Didn't want to overstep my bounds.
no. It was, like I said, I was a bit surprised that there was nobody here on the other one. So, because there was oral argument reserved. So very good. Go right ahead.
Thank you, Your Honor. Karen Goldberg Cook on behalf of appellant Alicia Lee. I'd like to reserve 5 minutes for rebuttal.
Very good. Go right ahead.
This case is the Titanic of social work as evidenced by DHHS ignoring the entire statutory scheme in federal and state law as to case plans being presented to the parent, filed with the court, and addressed at each hearing as to the finding of reasonable efforts toward reunification.
Isn't their obligation to draft them? And typically in my court, the parties would move for their admission. So it wasn't that DHHS didn't draft them, it's that they didn't move for their admission, right?
Until I got the prosecutor's appendix, they were not in the court file. I went through it numerous times. This had almost 60 transcripts.
I understand that. I understand that. Did you go through the social file as well?
Oh, yes.
Okay.
Yes.
All right. So my question again is, the DHHS's obligation is to prepare the reports. It's my understanding that the reports were prepared. They were just not admitted into evidence. I don't know why, because every single neglect hearing I had, I'm like, okay, here's our updated service plan. Here's our parent agency agreement. Here's the thing from the therapist. Here's the parenting classes. Here's this. I mean, so we'd have 15 exhibits, and those would be the reasonable efforts upon which I would rest my determination.
Right.
So I don't
believe these were prepared at all. I went through the file multiple times, talked to our chief deputy register. Whatever was in the appendix attached was an expansion of the record. I think the prosecutor probably dug them out of my SACWIS and stuck them in as an appendix, which is expanding the record, to which I'm objecting. The only case plan in this entire file was one half of a purported ISP, which was filed in approximately September of 2021. The children were removed in February of 2021. Every single time that we have a prelim in Oakland County, the parent is supposed to be told under MCR 3.965D, DHHS has an obligation to prepare an initial services plan, has what is required, and then Oakland County always order that is done to be done in 30 days. There's also MCL 712A13A parens 10 has that requirement. Also licensing rule MCR 4.219, 12.4219. And it's also, there's a federal statutory scheme, and to my knowledge, these children are federally funded. So
4E, they're 4E funded?
4E funded.
And they wouldn't be 4E funded if they didn't have the reports. There's no way they could get them 4E funded. I mean, I used to have to tap my head, rub my belly, and hop on the left foot this day and the right foot the next day to be able to get 4E funding. Because unless you have all that taken care of, they deny 4E funding.
Right. Well, it's possible this file could be audited and cost the county thousands of dollars. I've been involved in Title IV funds with funding fights with the Oakland County Probate Court years ago.
But you understand what I'm saying?
Yeah.
Unless all these reports were done properly,
Right.
they would deny 4A funding. You agree with me on that?
Well, I
No,
don't know.
No.
They should not give 4A funding, but I don't know what stage, if the department's been audited on this case.
But the state is audited constantly. I mean, every single year they would come through and they would look at our stuff because they were afraid that they were going to get files pulled from Kent County, as they do across the state, right? And if we had any I's not dotted, T's not crossed, we had to go in and do amended orders and things like that. But we were always at risk of losing 4E funding. So that's the point that I'm really kind of, it didn't strike me that if these kids are successfully 4E funded, all those reports must exist, which means DHS has created them. But for some reason, people didn't ask the court to accept them as exhibits.
I don't know. I've been doing this for 39 years. I was astounded when I read this file.
I was astounded too. So we were astounded together.
Yes.
But again, I think that based upon, everything that you're telling me and what I read is that for some strange reason, the people sitting in the courtroom didn't say, all right, Your Honor, I'd like to admit Exhibit 1, the updated service plan, Exhibit 2, the parent agency agreement, Exhibit 3, go on and so forth. And so
We have one referee in Oakland County that literally will not start a hearing until he's ensured that the USP or ISP is in the file. And frankly, he was my inspiration because I did the brief on NRA MJC. I said, I told him, I said, I channeled you when I wrote that brief because and this case was astounding. By the time they got to the initial disposition on the first 4 kids, 2 USPs were already due. And the only case plan in the file was 1/2 of an ISP. An ISP has 2 parts. One, telling what efforts were made to prevent removal. And secondly, what the parent's supposed to do. Every USP has 2 parts. And if we look at the holding in NRA MJC, this is reversible error, not to have these case plans in. And my argument is that mother had 3 attorneys. Not one preserved this argument for appeal, and I'm claiming ineffective assistance of counsel.
But again, that also goes to my point that it appears that mother actually went to her parent, they gave her a treatment plan, right? Because she went to things, she did things. And I can't imagine it was just that the court said, hey, these are the things I want you to do, but we're not going to write them down and give them to you.
DHS has to meet with the mother every month. They have to have quarterly FTMs. These are supposed to be planning with the parent, updating the service plans, updating the parent agency treatment plan. That was never done. There's not one signed PATP in the file, let alone updated service plans, which list all the social work contacts. I put in my brief on it's Exhibit 2, what the FOM says about what needs to be in the case plans.
And I get you on that.
Yeah.
Was there any order of disposition? There on the adjudication, we had the adjudication, but I didn't see the order of disposition. I can't remember the number that it is.
For the first 4 children?
The first 4 children.
No, I got an updated ROA yesterday on all 3 sets of kids, just to make sure I hadn't missed something. I couldn't find it either in the register of actions.
And I couldn't find it either. So there was an adjudicative order, but they require us to have the order of adjudication. It's like the JC 39 or something like that. So there's like the 38 is the adjudicative order and the 39 is the dispositional order. And my clerk is like wringing her hands because I'm saying the wrong number, but you know what I'm talking about.
Yeah.
There's 2 separate orders. We used to have them together and they made us separate them. And so I couldn't find it. I think that we had the adjudication for the younger 2. I know there was an adjudication order, but no disposition for the younger 2.
And there were no ISPs for the younger 2. Whatever was thrown into an appendix was never put in the court file. And at one point, the prosecutor says, well, the court said you need an ISP on, I believe it was I got to use the initials, child whose first name starts with I. And anyway, and somebody said, well, it'll be the same case plan, but you still have to do an ISP. There's no federal or state court rules, statutes, or anything that allows you not to do a case plan. The case plan isn't just for the parents, it's for the children too. It's for the court. All those things have to be in a file. And the attorneys should be able to challenge the case plans, ask questions at a review hearing, like, did you refer mother to mental health? If you get a USP, you see there were no referrals, then you can challenge that, the reasonable efforts. None of that was done. And as this court ruled in Ray MJC, a court report is no substitute for a case plan. So I believe that with the statutes, this is a failure of reasonable efforts, as this court said in Ray Simonetta. It says, I'm quoting, as part of these reasonable efforts, DHS must create a service plan outlining the steps that both it and the parent will take to rectify the issues that led to court involvement and to achieve reunification, citing in Ray Hicks Brown 500-79.
That was my opinion. And
Yeah.
the word in there is create.
Right.
They created. That's what they're supposed to do. So let me ask this, and I know this is a really kind of a strange question, and I appreciate it's nice to have these conversations with people who care as much about this as I have for the last couple of decades. Did you have a chance to talk to any of the attorneys who represented mom to find out, did you have the updated service plans or the IEPs or anything else?
The last attorney had a very condescending attitude, and he made very derogatory remarks about mom, so he wouldn't even answer me, the question. And the other one attorney now works for the AG, and she was only on it for New York Minute, Catherine Weatherington. And Judith Gracie was the only one that made one objection to the lack of documentation of reasonable efforts to prevent removal. So there's one attorney out of three that actually made an objection.
But that would have been for lack of reasonable efforts at the very beginning of the
Right.
adjudication, probably. But did any of them say, yeah, we never saw updated service plan or anything else? Because I can't believe out of all those attorneys, plus the fact that they're 4E funded and everybody else, that nobody had copies of them. I think everybody, it sounds like it, people had copies of them, which is why there was no objections, but nobody moved.
I don't think anybody had copies of them, but and I'm sort of astounded because this is our chief referee who was very aware of NRA MJC. When I got that opinion, which I did lose because of the trial attorney not preserving the issue, but I sent it to our court administrator and it went to all the referees. I said, we need to pay attention to this. And our chief referee has mentioned it in other hearings to me. So I don't know what happened, because she's usually very, very persuasive with the department. That she will always say, we expect parents to do what they're supposed to do. We need the department to do what it's supposed to do. She's done every role in the system. She's been a referee in LGAL, everything. So I don't know what happened on this case.
Okay.
I was 3 years and 9 months. There was a half of a case plan. So I would remind the court as to what Judge Whitbeck said in a case where Wayne County didn't comply with, the statutory scheme and a child died because of it. Quote, the court rules and statutes prescribing procedures for protective proceedings are not just technical obstacles that may be discarded in the name of expediency or even in the understandable rush to protect a child. Rather, taken together, the statutes and court rules reflect standards that are essential to the administrative justice. The statutes and court rules make the proper procedures in a protective proceeding clear. It should be equally clear they must be followed. And my argument is nothing was followed in this case. Mother did not have effective assistance of counsel. The error was obvious, plain, and affected her substantial rights to due process, because no attorney could challenge the due process and, reasonable efforts that were made, because mother was never, ever afforded the services. And she had 2 different social workers at one point.
That's not bad. For a 3.5-year case, that's not bad.
Well, yeah. But one of the social workers was from a private agency. So we have a split. So, and they say, well, one has full family responsibility, but I don't think anybody had responsibility for doing the job. And as to the best interest, the the oldest four children, even the LGAL, and she will argue, agrees with me that the burden was not met. They have been bounced around the system. They still have a bond with mother. The youngest two are with relatives, which is a factor that mitigates against termination. There's a strong component in both state and federal law to having siblings placed together. There's sibling splits. So I believe that we should reverse the entire case on the lack of reasonable efforts and lack of case plans. But if we're just going to get to the best interest, I believe that that burden was not met for any of the 6 children. Thank you.
Didn't the court though state that, well, the LGAL, which I know is unusual, was arguing against it, that the kids didn't want to go back to mom, as I recall. They did not want to go back to that.
Well, first of all, the psychological that was done, a lot of it was inaudible. And yeah, the children had mixed emotions because they did see some, some bad things. Yeah, and I'm conceding that point. There was domestic violence, et cetera. But at the end of the case, there was another child born, and mother now has custody of that child, and she has another one. So right now she has custody of 2 children that are not court wards.
Okay.
So how you treat one child is probative of how you treat another in Ray LaFleur and in Ray Dietrich infant and in Ray LaFrance. So
But those kids hadn't had to go through the system like the older kids were exposed to those sorts of things.
Right.
And mom is saying now, I'm safe with services, and then I'm safe because of the new baby and the other kids. But those older kids all had to go through this for 3.5 years and didn't have any permanence. So the fact that mom has kids that she has now, I don't think that's very persuasive with respect to what the court did, before those
I'm
kids
just
were
pointing
born.
out that, if mom's such a bad mom, why aren't her 2 newest ones in care?
Well, yeah. Well,
Because she did benefit from services. If you look at the end, even Whitney Bassinet or whatever her name is, the worker conceded that mother had made incredible strides at the end. She had gone through drug treatment court, et cetera. She had gone to PRISM. She was free of drugs. She was employed, et cetera. So she actually benefited from the services that were never properly offered, but she did benefit. I think the turning point for her was drug treatment court. But
She graduated from that treatment court, right?
she did.
Yeah, and then the GAL, she emphasized that the 4 oldest children share a strong bond with mother and continue to view her as mom and frequently ask about her. That's what she stated.
Miss
in her
McKelvey
brief.
is here,
Oh.
but she does have, and she's ongoing seeing these children because it's in a review stage, because the oldest, to my knowledge, the oldest 4, there's no termination. They're not MCI wards.
but are they, give me their ages, are they all 14 or older, so they would have to agree to termination for an adoption?
Honestly.
I know, she's saying no.
No, I don't think so.
I didn't think so either.
I
but
didn't
just
want to
wanted make sure.
misrepresent because kids have a way of sneaking up on you with
Yeah.
the ages.
No, I understand. I understand. So I appreciate it. Thank you so much.
Thank you.
Okay. Petitioner next, and then we'll go LGAO.
Morning, Your Honors. May it please the court, Joseph Shada on behalf of Petitioner, Department of Health and Human Services, and standing in for Danielle Walton, who wrote the brief in this matter. I will be primarily relying on Ms. Walton's brief, but want to emphasize a couple of quick things. First, with respect to the service plans, respondent mother does not cite any authority indicating that the case service plans must be filed. They must be made available and created. Absolutely. However, by statute, they must be created and made available. They must be obtainable. Albeit I will concede that it would be best practice to have them filed. That was not done in this case. However, they were attached as an offer of proof by Ms. Walton as Appendix H, I believe. Respondent mother's counsel has argued that they aren't a part of the record since they weren't filed. If this court has concern with that, it could remand for hearing on that, but I don't think it's necessary because this is under plain error review. First, that I don't think there has been a clear or obvious error that these reports were not created, but even if so, even if there were a requirement that they would have to be filed, respondent mother has failed to demonstrate that such an error affected the outcome of the proceedings. Respondent mother received services. She attended the court hearings. It was clear what was expected of her. She signed the initial service plan. There were no secrets about what she was supposed to do, her progress or lack thereof. There simply was not plain error affecting substantial rights here. And then moving on to the second best interest issue, I would want to emphasize the standard of review there too, clear error. The trial court addressed these types of issues going on in this case that respondent mother has raised on appeal regarding the lack of termination so far on the father for the two oldest children, and that there was still somewhat of a bond with varying degrees with the other children. However, the testimony was for the oldest child that this was an inappropriate bond because the child viewed it as necessary to parent. In addition, all these kids witnessed abuse, and that the trial court addressed all of these things and really focused on the fact that these children needed stability and needed permanence. And that was something that respondent mother, although she had made some progress, could not offer. And for those reasons, the trial court, its decision finding best interests for each of these individual children was not clearly erroneous.
Let me ask too, because I know in Wayne County, it's the, I think the Attorney General's office handles their child protective cases. And Oakland County, it's the Oakland County prosecutor, right?
Correct.
Okay. And was the person who wrote the brief, the prosecutor who was involved in the termination case?
At the trial level?
At the trial level?
No, they were not. Miss Walton wrote the brief on appeal. She has since left our office. However, there were a couple different trial prosecuting attorneys who handled it at the trial level.
Okay. And so did anybody go to them and say, hey, did you guys have these? Are they in the file? Did you ask questions based upon them? Did anybody move for their admission?
So Miss Walton, in speaking with her, she indicated that she spoke with the trial attorneys and that these were created. They just weren't filed. The reasoning behind why they weren't filed remains unclear. I do concede that would make this a whole lot easier if they were filed as far as creating a record.
But you don't have anything more as to why we don't have orders of disposition?
That I'm not sure on.
Anything else for this witness? Or I'm sorry. Mrs. Attorney.
So the statute, I'm looking at it, right? The agency shall prepare a case service plan that shall be available to the court and all parties to the proceeding. And I guess my question to you is, if it shall be available to the court, how is it available to the court if it's not in the file? So somebody has to ask for it.
The definition of available, one definition of that is obtainable. It was certainly obtainable. It was created.
It was created. You're saying it was created, but how is there any way to really verify that?
And that's why Ms. Walton attached them as an offer of proof. I understand it's outside the record, and if this court wants,
because that's the other issue, is that if there's a reviewing court, if it's not in the file, how do we review it if it wasn't in the file?
Understood.
Yeah.
And I see that point.
Mhm.
And 2 points in response. One, this court can always remand for further factual findings regarding these case service plans that weren't made a part of the record. And two, I don't think that is necessary, however, because it is plain error review. So we have to look at whether the error affected substantial rights, i.e. affected the outcome. And I think it's clear from this record that it didn't affect the outcome because one, respondent mother signed the initial case service plan, treatment plan. She knew what was expected of her, and she attended the hearing. She knew her progress or lack thereof, and it did not make a difference. And so having these updated case service plans filed, I don't think affected the outcome of these proceedings for those reasons.
Thank you. That's no further.
Yes. Thank you so much.
Thank you, Your Honors.
Now I finally get to talk to somebody who was actually there.
I am the only one who's been actually there.
Excellent. Welcome, Ms. McKelvey.
Good afternoon, Your Honor. Deborah H. McKelvey, the lawyer guardian ad litem for these 6 children. I think what's important to first point out is this case started in February of 2021. We were in the throes of COVID and everything was being done on Zoom. And I don't know that we necessarily had any, like, I don't remember not having a court report. I do not remember not at least having some document that everybody had that we discussed on the record, and mom knew what she was supposed to do. But, you know, everybody was still feeling out how documents were going to get to people because nobody was coming into the building at that point. Now, I will tell you that Referee Harris now, in the beginning of all our court hearings, make sure everybody has the court report and ask everybody if they have any objections to its admission. But I think we have to remember the chaos, for lack of a better word, where we were all trying to conduct business and figuring out how the heck to get, you know, paperwork, you know.
You said this started in December
February
21?
of 21.
February. Okay, that helps. Yeah, because it took us like 2 weeks. And once they closed everything out, so by April of 2020, we had the Zoom thing going.
Well, we had the Zoom thing going, but nobody, like a lot of us are, you know, I've been doing reported work for 36 years and I work out of my home. Most of our offices at home were not even, I used to have to go to Staples to take care of things because we weren't prepared for any of this.
Well, and everybody sent, at that point in time, everybody was sending everything electronically.
Exactly.
But all the workers, well, I shouldn't say workers. Usually the LGAL, mom's attorney, dad's attorney didn't have the ability to print these things out themselves. So they just looked at them online, which is probably what happened in a lot
Let
of these
alone
things.
whatever was going on in the DHHS offices as well.
Correct. So
I
my
just want to lay out.
No, but that makes perfect sense. Because I'm
Yes.
trying to make sense of this because you know.
Figured you were.
Yes, and you know, as I know, that there's no way they'd be fully funded if they didn't have all these reports.
No, and I appreciate what I've known Ms. Coho time, and I appreciate that, but sitting there, I wanted to say, but remember, we were all in the beginning throes of COVID at that point.
Which makes sense. So
And everybody handled that differently, and like I know at Oakland, we never started officially coming into the building, and it was only the criminal calls, and that was May of 2023. So, yeah, it took a long time, at least in our arenas, to even just have people come into the building to even try to file things in an appropriate manner.
Okay, so, and when was termination in this case?
The termination of the 6 children was October, I believe we had the best interest hearing October, November of 2024.
So there would have at least been, you would hope that.
There were some.
Yes.
And I can tell you that because we're still in court hearings, that she now is, that's the proceeding that occurs every time we have a court hearing in relation to everybody's received a report. If nobody has, then somebody, you know, in the clerk's office there while we're on Zoom gets it to us. So at least we can take a look at it and so forth. And so,
Well,
yeah.
and let me ask, in Oakland, was it the same thing that happened in Kent? That if you guys didn't have it, and we made them do it at least 5 days before the hearing,
We still
even
do
though the
that.
statute says 7, they would say, I object. I got a 110-page
Right.
USP.
Right.
We can't go forward. And then we would adjourn.
Right.
Okay.
And we still do that.
All right. So,
And we still do that. So,
so can I then assume backwards that if there were no objections to the lack of the USPs and the ISPs, that people had them?
that's something. I would agree to that because minus the last attorney that Miss Lee had, Judy Gracie in particular, she was a zealous advocate for Miss Lee. And she would not, in my opinion, and I've known her a long time as well, she would not, in my opinion, have not done anything without having adequate documentation. And I know she always spoke with Miss Lee prior, you know, to every court hearing we had.
Okay.
So I just can't envision that the attorneys and the workers and everybody who was present at that time, we all had enough to work with and we all knew from our roles what was expected of, because we also had 2 parents or 2 attorneys for the 2 fathers. Mr. Alexander and Mr. Lee, who were and we had big issues with them because both of them were incarcerated.
Oh, even better. Oh, those are fun.
Yeah. So, you know, just to give you a timeline, since we're working, when it came in February of 21, it came in as an initial petition to terminate because when mother at 13 or 14 came into care due to a substance abuse issue on the part of her mother. And she aged out in the system. And if my memory serves me correctly, because that was a large issue for Miss Gracie, and I
Mhm.
appreciate that.
And usually if we had parents who were never parented, I also gave them more time.
Right,
because they
and
had
that's
no-
why, I guess that's why I'm a strong advocate for Miss Lee as well as I am for some of these children. Some of these children, the last two, if Miss Lee was standing here, she would tell you it is in the best interest of those two children that they should be adopted by the two sets of relatives that they're with. Unfortunately, that last attorney she had really didn't handle it the way someone else would have, in the sense that we would have dealt separately with
Yeah.
those two.
Okay.
And I argued that, and she would, if she, because I'm still in touch with her because of the last two
Yeah,
children she's
okay.
had. And she would tell you that. It's these oldest four, and to correct you in relation, with all due respect,
Oh, it's okay.
the oldest child, S.A., she is parentified. I won't deny that. But she was also profoundly impacted by, or and still is, by her father. And so when they had the psychologicals for the best interest hearing, she was the one who kept saying, I want to be with family. And I don't want to be with my mom. And she has, and that has still been a huge problem because we have tried, we meaning CPS and myself, have tried to and the prosecutor's office have tried to terminate Mr. Alexander's parental rights twice. And we're still dumbfounded that we're not, or it hasn't been accomplished. And now that child is being, in particular, her and her brother are being profoundly impacted by the fact that we haven't done that.
Mr. Alexander is impacting them.
Yes. And he has to be admonished constantly at court hearings by what he says in his phone calls.
Okay.
Because I can tell you that at the time that we did the best interest hearing, number one, is we had no permanent plan for those four children. The two sets were in two different long-term foster care placements, and the belief was that that was going to be a permanent plan. They both blew up for various reasons. And so at the time of that best interest hearing, the two LLs were placed in a foster home, and right now they remain there. And then subsequently, within a week or two time, DHHS was willing to get permission they had to do a little fudging to be able to put SA and KA in with those other two. So those four are together, but we have one set that now, I mean, has been there, but one set we had both parents terminated, and one set, we do not. But at that time, they had just been placed there. So when you look at Olive Metz, we had no permanency. We had no finality for them. But more significantly, I can remember, and I still visualize, I can remember those first court hearings with Miss Lee, where, she'd be sitting on a couch and it was pitch black and she'd be smoking a cigarette and she'd be totally oblivious. And Referee Harris would have to sit there. But to see where she came by October of 24, because of her mistake, in particular with Mr. Lee, she got arrested on possession of cocaine. And because it was, she had no prior criminal history, Judge Poles gave her a personal bond. Well, Alicia isn't prone to necessarily doing her drug testing. I believe, and Judge Poles doesn't know this, but she saved Alicia's life because at some point when they did a raid on the house and she got arrested, when she got out, Mr. Lee, excuse the expression, but beat the crap out of her. And Whitney Kastner-Bessonnet, the worker, had called me, sent me texts. And so Judge Poles revoked her bond again because she continued not to test. Now, Mr. Lee thought that she wouldn't come to testify. It's typical Pontiac. And she probably wouldn't, but she was in jail. She came. Whitney Kastner-Bestenet and I sat in that courtroom and watched her testify. You know, Mr. Lee just spat out a cow, but that was the first time, we saw strength in her. And Judge Poles accepted her in the adult treatment court. She told me the first time she was with Judge Poles, she was scared to death of her, understandably so. But Judge Poles let me go to her graduation, which was in January of 25. And the attorney who runs that program said, because I would check in with her every time we had a court date, is Alicia just needed somebody to see some worth in her. And they did. I never saw, no disrespect to Judge Poles, she could be a little rough on her crim call, but that woman has so much compassion and joy when she sees those women graduate, and same with Agent Bowers. So and the other thing, when we were at that best interest hearing, she had already given birth to, she had been doing so well that, oh, I'm sorry,
That's okay.
WD, I'm sorry. That referee Harris never removed her. By January of 25, that was a petition to terminate. They was reduced to a temporary wardship. Alicia never lost custody. In June of 2025, that case was closed. She graduated from ATC in that January. And when Whitney Kastner-Bestenet testified that when Judge Garrett read my piece from my brief, is Whitney had testified that with the time that we knew we were going to have with respect to WD, that we had no permanent plan. Those kids today still ask about her. They still care about her. They still want to know what's going on with her.
But they don't want to live with her, right?
No, actually, SA hopes that this all goes in their favor and they can go back home.
But what about the other kids?
Well, you know, that's tough when you've got the two younger ones who have been in that placement, you know, for so long. And, you know, I can't honestly say that, I don't know that they would be upset. Would they miss the foster mom? But that foster mom has been wonderful and has agreed that if Alicia is successful in being able to try to reunify, she's going to maintain contact with them and be a source for them. And I believe that. But
I'm sorry. Let me ask you then, why can't I find orders of disposition in this file?
I don't know, because I was looking at the register of actions and I know we had the particular court hearings.
And I mean, you need the order of adjudication, you need the order of disposition, you need the
Correct.
permanency planning hearings, but I couldn't find.
I can't answer that because
Okay.
I know I continually receive, now everything obviously is sent, you know,
I know.
email, and it always has been. So, you know, I honestly can't answer that because I've never.
All right. So I'm guessing your position is that it's not error that there's no reports in the file because the reports were obviously shared, but just not admitted into evidence.
I can't in good conscience say it is because, yeah, I can't. And I do support that. I think it is in the best interest of
Go ahead.
No, that's okay. I see in ET that, you know, termination is in the best interest of them and that should stay. But I do believe it wasn't in the best interest of SAKA and the two LLs to terminate just because of the level of progress and the fact that I think we could have had additional time. And
Even after 3.5 years? Oh my.
well, I you know, Your Honor, it's tough when you haven't walked that walk to see and to deal with these kids. If Whitney Kastner-Bestenet was standing here, she'd tell you the same thing, that she had that same feeling from those 4 kids, you know, and they were torn. They were in 4 or 5 placements over the history of this case. And the only real, believe it or not, the only real stable person they ever had was their mother. And I remember the first the termination trial that we had on both of them in Mr. Alexander and Miss Lee, and it would have been in the summer of, it had to have been the summer of 24. And I remember telling referee Harris that Miss Lee parented those kids for probably 3 or 4 years before they came into care. And those kids were amazing children. They were not negatively impacted. They really, mom had parented them and they were good kids.
Even though the oldest was parentified?
Well,
That's usually for the kids who, they're the ones who are looking out for everybody else and for
Well-
their parent because their parent can't look out for themselves.
true, but I won't, I used to watch Alicia in her supervised parenting time at the Pontiac Library. And knowing SA as I do, as the oldest child, she's gonna help. I mean, I'll be honest with you, I was the oldest child by 3 minutes and I did the same thing.
But that's different than the parentification. Parentification is, I can't sleep at night because I'm not with my mom and I don't know if she's safe. I can't keep her safe. I
Well-
don't have my eyes on her to keep her safe.
Well, that's true, but she was focused on everybody and Alicia, I can't say Alicia didn't look at her, but does that simply mean that, Alicia wasn't a decent parent to these kids?
And so was the court erroneous then when the court concluded at the best interest hearing that the children were not united in their desire to return to their mother?
I do. For those four, for the four oldest, as I said, I think she was correct in the other two. But I do. And to me, it was more, what would we have lost? We had no permanency plan anyway. They had no more stability or finality than if we had, even just waited out that 6 months or so period before, we made that final decision. And maybe if she didn't do anything, it would have been a different story, but knowing now what she accomplished.
I know, but that's again, hindsight. We can't look at it with hindsight. We
No,
just can't.
Well, I understand, but again, as you just said, I lived this from February of 21st and I'm still living it today.
All
So.
right. Any other questions?
No.
Thank you.
You're
Thank
welcome.
you so much. Any rebuttal?
Just a little bit.
Briefly?
I know everybody's tired and wants to go to lunch, but I would point out that the juvenile code at 712A.13A refers to the Child Care Organizations Act at MCL 722. 211 or 111. And it refers to the agency rules, and the rule for service plans are 400-12418. At parens 4 says an agency shall place service plans in the case record, number 1. So the fact that there were just court reports and not case plans, they have to be in the record.
The case record,
Secondly,
isn't that at DHHS, not in the court? That's what it refers to.
well, I don't know how the court can evaluate at review hearings under 712A.19 and at a permanency planning hearing, MCL 712A.19A, corresponding court rules, MCR 3.975 and 3.976, where the court has to look at the parent's compliance with the case plan for every review. How can the court look at mother's compliance with the case plan when the court doesn't have a documented case plan in the file? Thank you.
All right, thank you so much. That case will be submitted. And that's it for today. I believe we're done. Thank you so much.